twice. The Court of Appeals, Division 1 is now in session.
Yeah, you may be seated. This is the time set for argument in Oberg versus Oberg. Our case number is CA20 0468. Each side will have 20 minutes for argument. Appellant is responsible for reserving any time that you'd like for rebuttal. And these proceedings are being video recorded. We would appreciate it if you would identify yourself and your client when you begin your argument. We've conferenced this matter already. We've read the briefs. We're familiar, we think, with the facts and with the arguments. And with that, counsel, you may proceed.
Thank you, Your Honor. Good morning. My name is Christina Hamilton, and I represent the appellant, Margaret Oberg, and I would like to reserve 3 minutes for rebuttal. There are some undisputed facts that I think require that the decree be set aside. On its face, the decree shows that husband got $170,000 worth of real estate and wife got no compensation for that. At trial, husband admitted that that was not a division of 50-50 on the real estate. Husband admitted during trial that wife cannot support herself on her income, that they had been married for 22 years, that they had moved multiple times to support his career, and that he was making $280,000 a year. Yet she was not granted spousal maintenance. The postnuptial agreement was not attached or incorporated into the decree or the petition, although it was referenced in them, but it was not in front of the court. Wife was not represented by counsel during the negotiation and signing of the postnuptial agreement, and the court issued the decree, the underlying court issued the decree by motion, so there was not any testimony as to fairness. Nowhere in the rulings of Judge Marwill, when we filed to set aside the decree, did she even address the issue of fairness. It's not even mentioned in her minute entry. And that was obviously the prong of both 25-318, 25-319, 25-317, Harbor and Austin, and Rule 69 that she would have had to have met. In fact, she said that the decree was different than the law would have otherwise required, absent agreement of the parties. And not only does she never address fairness, but in the briefing, husband never addresses fairness either, other than to say fairness is in the eye of the beholder. Whatever they agreed upon is, quote, fair, and or that because of wife's marital misconduct, that's a proxy for fairness. So based upon the law, I believe that the decree has to be set aside. The husband does not address 25-318 or 25-19 in his brief, other than to say that fairness is not an assessment to be made by the courts, but rather was adjudged by the parties when they agreed to the terms of the postnuptial agreement. But that's wrong for a number of reasons. Number one, Wick v. Wick, our Supreme Court said that the trial court is obliged to achieve a fair and equitable distribution of property and is not foreclosed from doing so by the parties' agreement.
Counsel, let me ask you, given your focus on fairness, and that comes through in the briefs, what's the remedy that you're seeking here? Is it a remand for determination, for a fairness determination, or is it something different? And if it's something different, help me understand how that's not procedurally important.
Okay. It is a request that the decree be set aside so that the issues of merit can go forward on the issues of division of real estate and on the issue of spousal maintenance.
Without regard to the postnuptial or with regard to?
Husband can assert the postnuptial in that situation, obviously, and we would assert the defense that it is not fair and therefore it should not be utilized as the proxy for what the terms should be.
Does that relief that you're addressing now properly square with the procedural history of this case?
Meaning because wife didn't file her answer. Correct. And therefore the default.
Correct.
I believe that under the Burt case, that the court is supposed to set aside default decrees when there is a meritorious defense and when it's so unfair as to be harsh reality. And in this case, which provides a basis under ARFLP 85B6 to set aside the decree. Because in this case, the wife of 22 years is walking away with no spousal maintenance and 50% of the real estate not being compensated.
And so your request of relief, if I'm hearing you, is to undo everything and have a trial de novo?
Yes. I mean, meaning...
How does that account for the default, which I get was challenged but was not set aside?
Right, I understand that. And so that's where we have to go to Rule 85, correct? And Rule 85 says we're supposed to show one of those factors, and the Burt case is specific in saying that if the ruling is not fair and equitable, we would rather have the decree set aside because otherwise you're going to have a harsh reality that that's not what the court wants. The court wants fairness. And so under Burt, it would be fair to set aside the decree because it's clearly not fair. I mean, it's kind of a round circle, I agree.
Well, is that, let me ask you just one other question. Is that fairness the same determination that the statutory fairness requires, or are you talking about something different?
No, I'm talking pretty much the statutory requirement, meaning...
Let me interrupt you. You said pretty much, and I want to understand your argument, because pretty much isn't necessarily the same.
Okay. My argument is that this decree is so unfair under 25, 318, 19, 17, Harbor and Austin, that it must be set aside. And then there would be a trial on the merits with regard to all of the issues, in which husband could assert post-nuptial agreement.
And so and I promised you I would ask only one more, but
Okay.
let me ask one more still. So you're asking this court to find that the decree is unfair, as opposed to remanding for the trial court to make a fairness determination. Those are different things.
You're correct, and I am asking for the decree to be set aside, and that then the normal process would go forward in the court below.
But just so I'm clear, set aside is, and I've told you twice that I would ask you my last question,
okay.
I'm sorry, but set aside is unfair as opposed to set aside for a procedural irregularity.
Set aside because under AR FLP 85B6 says that the court can set aside the decree for any other reason that justifies relief. The justification for relief in this case, just like in Burt, is that this is such an unfair decree that it is improper to hold wife to it, as well as it's a meritorious defense for wife to say, hey, I'm entitled to spousal maintenance, and hey, I'm entitled to my 50% of the community property. And there's 3 prongs to the set-aside test, and no one's suggesting that she didn't come to the court in a timely manner. So, getting back to the other issues, the Burt case does say that the court can substitute its judgment for that of the trial court if there are no facts in dispute, and here there are no facts in dispute. The record is really clear that the property division was not equal and wife was not able to support herself on her own income. The marital misconduct portion of this, I don't want to spend a lot of time on, but it appears that husband's brief is solely relying upon marital misconduct as a basis to uphold the decree, as it seems that Judge Marwell's decision seems to be that wife knew the consequences of her action. I just want to point out to the court that it's kind of an ironic and unbelievable argument in that, first of all, marital misconduct under the statutes is not supposed to be considered. And Judge Marwell even said the only reason she was considering it was because she wanted to understand what the reconciliation efforts were between the parties during the divorce process.
Counsel, when you say under the statute, you're referring to 318 and 319, not 317, correct?
Correct, yes.
Okay.
I'm sorry if I misstated that. But second of all, not only that, but wife signed a prenuptial agreement on October 16th. By October 26th, her psychiatrist had admitted her into the Meadows for a 6-week alcohol and sex addiction program, and there was no evidence of any kind that between October 16th and October 26th, wife had done any marital misconduct, and husband then filed his petition for divorce while she was in the Meadows. So all of their brief that suggests that marital misconduct, she gets what she asked for, is basically their argument, has no factual basis in the record because there was no demonstration of anything during that period of time. The other things that I just want to point out is that in the Austin case was very clear in affirming that Harbor applies to all agreements between spouses during their marriage that affect property rights, that normal contract principles of if you read it, then you're assumed to understand it, etc., do not apply, and that yet seems to be what Judge Marwell was doing, is saying if you read it, you're bound to it, but that's inconsistent with Austin. And also, the Austin case does identify that it is the court's belief that people should be represented by attorneys when entering into postnuptial agreements, and clearly wife was not represented at any time during the postnuptial process.
Counsel, is that a stated requirement in the case, or did they just say that that's laudable?
That's a good question, and I don't know that I can answer it anything other than to say that was something that they kept pointing out, that wouldn't that be best if attorneys were involved, but I don't think they ever said the fourth prong is now that people will have legal representation in entering into the postnuptial agreement. That said, in this instant case, everyone clearly knew that wife was not in a healthy state of mind during that period of time, not represented by counsel, and so
So maybe it's an indicia towards a fairness evaluation?
Yes.
Is that what you're saying?
Minimally, yes.
Okay.
Again, the whole concept of marital misconduct can't be a basis to support this agreement. And finally, I do want to point out that their briefs reference the Rubenstein and the Dunbar cases, both of which were predating Austin, and both of which were not analyzed under Harbor, and both of which said sort of the equivalent that they're arguing, that you signed it, you're held to it. But again, Austin is saying, we don't agree to that anymore. We agree that Harbor applies to any contract, no matter what you want to call it, that spouses entered into during the course of the marriage. And in that case, you have to hit the three-prong test, fairness being one of the prongs. Fairness being a prong that was never even addressed in the underlying order that refused to set aside the decree. Fairness that they don't argue other than to say you're held to what you signed, and the marital misconduct argument. So for all of those reasons, I think that the decree needs to be set aside to answer Judge Thunman's question, and that the process in the court below should go forward. And in all candor, obviously the decree was filed for in December. By March, there was a decree. There was no prejudice to husband having it set aside and having the hearing be heard on the merits. And the case law is very clear that the court prefers hearing on the merits over a default decree. So I don't really understand why there would be any prejudice to him in allowing the matter to go forward. Again, he can assert the prenuptial agreement, and again, the court below can determine whether...
Postnuptial agreement.
I'm sorry, yes, beg your pardon. The court down below can assess whether or not it meets the Harbor test. I also want to remind the court that under Wick, Harbor, all of those cases all talk about the three-prong test, fairness being one of them. And so the argument that fairness is something different in the postnuptial agreement really doesn't ring true to me, because it is consistently applied throughout cases, whether we're talking about a separation agreement, whether we're talking about a postnuptial agreement. The court refers to Harbor and says you have to meet the three-prong test. Finally, Your Honors, we have requested our attorney's fees and costs in having to bring this appeal to your attention. I'll adjourn now and reserve my time. Thank you.
Thank you. Counsel.
Good morning, Your Honors. My name is Amy Sells. I'm from Tiffany & Bosco, and I'm here on behalf of Mr. Oberg. Pardon me. This appeal arises from a motion to set aside a default decree, and today I'm not going to be focusing on 85B1 having to do with excusable neglect, or 85B3 that has to do with misconduct. I think that those aspects are adequately covered in the briefing, unless you have questions for me on those. What I'd really like to focus on is 85B6, and that has to do with whether there are other reasons justifying relief from the default decree. And this appeal really does boil down to two issues. First, whether the postnuptial agreement's terms as incorporated into the default decree were fair or equitable, and then two, what standard does the court apply in order to make that determination? Ms. Oberg has, in her briefing, covered a bunch of statutory standards and some case law standards, almost as though they all apply simultaneously, and they don't. So we have 25.317, 25.318, 25.319, and then in Right Harbor. Those are the applicable standards that I'd like to walk you through. 25.318 and 319, those never came into play here. 318 concerns property division. 319 concerns spousal maintenance and calculation of that spousal maintenance. Those come into play when there is not already a pre-existing agreement between the parties. And that is exactly what Judge Marwell meant in her ruling when she said...
But you agree that the pre-existing agreement, there has to be indicia of fairness in that agreement?
Yes, I do.
And I'm hard-pressed in even looking at your briefing and at the agreement. It seems to focus on, there doesn't seem to be any discussion about what's a fair distribution of assets. It seems to be a focus on improper conduct by wife. If this doesn't stop, then everything just goes in this direction. I don't see any indication of this would be an equitable division of property.
Yes, there is a section. The sections that talk mostly about wife's misconduct are the sections that focus on 85B1 and 85B3, talking about misconduct in entering into the postnuptial agreement and whether or not she had her failure to respond in the family court proceeding was excusable neglect. So that's why we focused there. More so on...
But the brief suggests that as consideration for the agreement, wife agreed to avoid misconduct. How is that consideration for a property division?
Because the context of the postnuptial agreement being drawn up is that the wife understood that her husband was ready to divorce and that the reason why he was ready to divorce
But it says as consideration for the agreement. That suggests that she's getting something in return. I'm just hard pressed. I'm not understanding that sentence in your brief saying as consideration for the agreement, wife promised to cease any misconduct. How is that consideration that she's receiving?
The point that I was trying to make is that the case law says that husband and wife are free to divide their property however they want to. And that actually gets back to the Harbor Standard as well. And you can enter into contract however you want, but the contract has to comply with certain standards, and one of those standards is fairness and equitability.
But can I, to follow up on Judge Catani's question, I think one of those standards is consideration, just garden variety, contract, benefit burden, sort of contract formation issues. I think Judge Catani's question, one of them was focusing on what consideration here, what benefit of the bargain did wife get?
That she would be able to remain in the marriage, which is something that she desired, provided that she did not continue with the marital misconduct.
And what, under Title 25 as we take it today, what is the best case that you have for that being valid, cognizable consideration of the contract?
I don't think that any of the cases that we've briefed speak to that type of consideration for contract.
And I'm aware of none either, so I share that with you, but that to me is telling.
In that the postnuptial agreement is flawed because it did not have adequate consideration?
That's the question, not your position, I'm assuming.
Right.
But that is the question, or at least a pretty basic question, and we also want to talk, of course, about fairness.
Right.
Because the record is almost non-existent on that from my review, at least, of it. But for the postnuptial agreement to even get to fairness, it has to be a valid contract, right?
Right.
And that's really what we're pressing you on.
Well, there were other cases that talked about coercion, for example, where one of the parties said that their spouse had forced them to enter into a postnuptial agreement or a separation agreement on the threat that they were going to divorce. And I think that even if we set aside marital misconduct, the bottom line is that Ms. Oberg wanted to remain in the marriage, and there was a threat. She says that she couldn't remain in the marriage unless she were to enter into this postnuptial agreement. And so I think that perhaps this case is analogous to that. I don't know that we need to focus on marital misconduct as consideration per se for the contract. It's the idea that she wanted to remain in the marriage, and in order to do so, she entered into this contract.
So that means you could have a legitimate agreement that we will stay married under these circumstances.
Yes.
But that begs the question then of, is this an agreement that is inherently fair or has any indicia of fairness in terms of what will happen if we end the marriage? And that this agreement doesn't seem to address that at all. It just seems to go to, we will only remain married if these conditions are met. And that seems to leave out entirely any question about how assets will be divided upon if the marriage doesn't remain intact. The fairness of that, I agree, it specifies it, but it doesn't seem to address fairness of a division.
That the agreement itself doesn't address fairness?
What indicia is there that there's any element of fairness in the way the assets are divided?
I see. And there is a section in my brief that does talk about the postnuptial agreement I believe the heading actually says the postnuptial agreement is fair. And so we talk about the fact that you don't just look at what Ms. Oberg didn't receive insofar as the spousal maintenance and the property division. I mean, and by the way, what Mr. Oberg received in terms of the family household, he received subject to the mortgage and the risks that come along with the mortgage. But what Ms. Oberg received was half of the marital estate's remaining assets, which totaled $450,000. She was also receiving at that time $1,000 per month in child support. And so what you find that even during trial, Judge Marwell had said that, look, spousal maintenance the purpose of it is not to support the spouse for the remainder of their days. The purpose is to act as a bridge to allow them to get back up on their feet until such time as they can sustain themselves. So I think that is an aspect that the judge was looking at in terms of fairness.
But did the judge make a finding on fairness? I was reading the order as simply saying, you agreed to this, so I'm going with it.
The judge did not make an express finding of fairness, and that is actually okay because the judge did not need to make an express finding of fairness in the ruling. And in fact, there is a section in Ray Harbor that actually says the trial court will be deemed to have made every finding of fact necessary to support its judgment. There's no case law that says that when making these fairness determinations that the court has to tick through expressly each of the bases for its fairness determination.
Is a finding of fairness a finding of fact or a conclusion?
I think that would be I'm not sure.
I'm wondering if it might be a conclusion of law. And so I understand your quote from Harvard, but I wonder if that may not take us across the goal line on that specific issue.
Well, I would read the ruling itself as upholding the postnuptial agreement and upholding
there's no
the
question.
decree.
What we struggle with, given this appeal, is where is the determination by the court that I've looked at this, I've considered both arguments, and not only is it enforceable under contract law, the offer, acceptance, consideration, certainty of terms, but it's also fair, given that we're in Title 25 with at least one minor child, right? So you have the Hayes v. Gama kind of overlay, the best interests always, are a backdrop to how these statutes in these cases are resolved, and that's my struggle.
Yeah. And I think that what we need to look to is a few things. That at the beginning of the trial, well, first of all, let me back up. In terms of making a fairness determination, the point that I was going to gradually get to is that 25317B is not applicable here, and the standard that does apply here is in Ray Harbor. And so what it calls for is a fairness determination to be made once there is an objection to the terms of the postnuptial agreement. And so here, what the court did at the default decree stage, it hadn't heard anything from Ms. Oberg whatsoever, so it complied within Ray Harbor insofar as it entered the default decree. And that was proper, even though the court at that point didn't make a fairness determination. Harbor permits that. It is at the motion to set aside the default decree stage where that obligation comes into play. And here, I think to address your question, Your Honor, we can take solace in the fact that the court did conduct that fairness determination, and by doing various things, by entertaining the briefing on the motion to set aside, and the briefing contained exhibits, it addressed the facts, and addressed the law. The pretrial statements the parties submitted, also addressing the facts and the law. Then the court, absent any obligation to do so, holds a trial, whereas Hutke says that the court did not have an obligation to set a fairness determination, but actually holds a trial. And at the beginning of the trial, in the transcript, the court sets the scope and says, we're going to talk about two issues. The first is whether there is a procedural, not a procedural, but some sort of a deficiency in the entry of the default decree. And then we're also going to talk about whether or not the postnuptial agreement is equitable. And so then she proceeds to take evidence, including testimony from Mr. Oberg and Mrs. Oberg on a variety of topics, but including whether or not the spousal maintenance award is equitable and the division of the property is equitable. And then she comes out with a ruling, which granted doesn't have that magic language. But
what you've described in terms of the procedure is sort of a procedural fairness kind of due process opportunity to be heard. But it strikes me here that we're looking, the law requires something more, a substantive look at the agreement itself and a determination that, hey, this differs from the law, but in the unique circumstances of this case, and all this information that the trial judge has received, that it is substantively fair or that it is substantively unfair. And it is the latter portion of that, if indeed that's required, that we seem lacking.
Right. And I have not seen any decisions that would indicate that that level of detail is required in the ruling. And so
what I'm talking about is even a determination, yes, this is fair. We don't have that.
We know that she considered fairness and that ultimately she upheld postnuptial agreement. Right. But no express finding of fairness. Implicit, yes.
Implicity, I guess I'm still reading her order as suggesting that parties agreed to this, so I'm not gonna change it. That doesn't seem to be an assessment of whether what they agreed to was fair.
Right, and again, I think it goes back to the argument that I made previously that she received all sorts of evidence concerning whether or not these terms were fair, and we don't have to perhaps, but I would like to assume that she took all of that into account.
But she even suggested that it doesn't seem to be, this isn't what I would view, I'm putting words into her mouth now, but this isn't what I would do, but if this is what they agreed to, fine. And you're suggesting that's enough to say it gets to the threshold that we can conclude that there's an element of fairness there.
I think that what she was referring to and what you might be referring to is where she says that she'll uphold the postnuptial agreement, quote, even if it's different than what the law would have required absent an agreement of the parties. That is a reference to the two statutes that don't apply here. So that's 25-318 and 319. So even she's upholding the postnuptial agreement.
But you agree the law requires an equitable division of assets, a fair distribution of assets, and I realize it doesn't necessarily have to be 50-50, but there has to be some indicia that there's been an equitable distribution of assets. And what do we have that shows that? I realize, and I completely understand the position that husband takes over debt, and it's not simply a question of you get half of the equity in house. You have to consider everything, but what do we have that shows that there's a reasonably equitable division of assets? A fair division of assets?
Well, what I go back to is the fact that she did not leave empty-handed. It may not be, like you said, a 50-50 division, but the scales still don't dramatically, tip in Mr. Oberg's favor. He still did assume risks by assuming the mortgage for the home, and she still did come away with $450,000 worth of assets. And she is employed, and she is capable of supporting herself. And then we go back to the purpose of spousal maintenance and how it's not meant to support her indefinitely. And so all of those things combined weigh
in your
in
view,
favor
had there
of
not
it.
been a default, would this have been the same result?
Had she not defaulted, the analysis would be, actually, it is possible. Yeah, actually, it is possible because ultimately there would be, I would assume, that Ms. Oberg would object to the terms of the postnuptial agreement. There would be a hearing. The hearing would be substantially the same as the hearing that already occurred, same sorts of evidence, and yes, the same result. And perhaps I'd still be standing before you here today. So yes, I think that just to sum it up, 25.317 doesn't apply here. It applies to separation agreements, but even in the event that it does apply, the fairness determination was made by the court when it needed to, which was at the motion to set aside stage. Ms. Oberg was given her day in court to be heard on the issue of fairness, and the court ultimately upheld the postnuptial agreement and the default decree. The true standard that does apply here is the In Re Harbor standard, because that case involved a postnuptial agreement, but it's very similar to 25.317 insofar as it does still require an actual affirmative action by the wife in objecting to the postnuptial agreement. But the analysis is still the same. Ms. Oberg received that fairness determination in full, and the judge actually went above and beyond in providing her a trial on these issues. The only, and as Judge Thumma was asking appellant's counsel, I think that this is a case that it is one of those where you got to take a look at what the relief that the appellant is seeking and what the practical effect of that is going to be. And so she has said that she wants this decree to be vacated and remanded to the court to make a fairness determination, among other things. And so really what she's asking for is a second bite at the apple. She's not entitled to that.
Is it a second bite at the apple if we were to just send it back and say there's a lack of findings and we leave it to the Superior Court to decide whether further proceedings are necessary before making findings?
Well, I feel, number one, the opportunity for findings of fact and conclusions of law was actually made. If you look at index of record, number 38, that's the minute entry that actually set the trial. And the trial court directed the parties, if you want findings of fact and conclusions of law, you need to submit them to me. Ms. Oberg did not submit them. So any absence of findings of fact and conclusions of law in the ruling is a product of Ms. Oberg's inaction, yet again. The only other thing that I'd like to ask has to do with fees. Ms. Oberg is seeking fees under 25.324, which is standard for a family law case. I would just ask Your Honors to take a look at Rule 69 that says that this court has the discretion to decline the award of fees to Ms. Oberg under ARS 25.324 because she's challenged the validity of a Rule 69 agreement. This postnuptial agreement is a Rule 69 agreement. It was signed by the parties, submitted to the court for approval, and approved to the court. So Ms. Oberg is not entitled to fees under Rule 69C. And, Your Honors, that's all that I have.
Thank you.
I'm concerned and confused at the argument that 25-317 doesn't apply because that's what 25-317 says. If there is an agreement between the parties and you're asking that to be invoked as the terms of a decree, then it is the court's responsibility to assess that agreement and determine whether it's fair. And that's set forth in the Sharp case where it says, this obligation is in concert with the statement of the Supreme Court in Wick that the trial court is obliged to have a fair and equitable distribution of the property and is not foreclosed from doing so by the parties' separation and property agreement. To hold otherwise would, in effect, allow parties to a dissolution to completely defeat the authority expressly conferred upon the trial court by our statute. And I further remind that while Rule 69 does say that the court can enforce agreements of the parties, there's a specific provision in there that says, but the court has to approve the agreement, which then it throws us back into 25-317, which has not been eviscerated as far as I'm concerned, about the court's responsibility to make a determination as to whether it is fair. The second thing that I want to point out is on the face of the decree, it demonstrates that there was $170,000 worth of property going to husband for which wife got no compensation. The mortgage is listed in there, but it says in the decree the home is worth $550,000 and the debt is $429,000 and the lot is worth $50,000. So on its face, someone should have been making a determination that this was not fair. I also don't really understand the argument that 25-318 and 25-319 don't apply because, again, if you're entering into a postnuptial agreement, it has to meet the Harbor Test, and the Harbor Test is premised upon the dictates of the statutes 25-318 and 25-319.
So, counsel, are you arguing that fairness, quote unquote, is necessarily bounded by 318 and 319?
Yes.
That the only way to be fair is for a postnuptial agreement to comply with 318 and 319?
Yes, with this comment. Could the postnuptial agreement say, in lieu of getting my half of $170,000, I'm going to get X? Or he's going to pay me spousal maintenance for a longer period of time than what I wanted? Or something. There could be a substitution, if you will, for her half of the equity. But I don't think you can just have a postnuptial agreement that says she just doesn't get her half of the equity. And yes, 25-318 and flowers would apply to say, yeah, it has to be substantially equitable or substantially equal. So yes, I am saying that. And similarly, when you have a wife of 22 years who's making $12 an hour as a bakery assistant at Bash's, working part-time, and the husband's making $280,000, yes, I think under 25-319, she is absolutely a candidate for spousal maintenance. They did not even deny that at the time of trial, and husband agreed she couldn't support herself. And the only way they claimed that it was, quote, fair under 25-319 was to say if she used up all of her assets as well as her income, then she could support herself, which is totally contrary to deferage.
So, counsel, your position is a decree, agreed upon decree, not a decree by default, an agreed upon decree, could never vary in 318 and 319?
I think it could vary, but I think that there would have to be reasons stated in there and or testimony stated as to why this is a little bit aberrational from 25-318 and 319.
Let me ask you, could a agreed upon decree in that context, again, more hypothetical world, but could that divide marital assets inequitably and be enforceable in your view?
I think if there was some other consideration in there for it, again, you take all of the house and you take all of the lot, but you're going to pay me a longer period of time for spousal maintenance.
And the reason why I'm asking is you're talking about different allocation of assets as opposed to, but still could be right at 50-50. And what I'm saying is it your position, hypothetical issue, that it could never be 30-70 ever?
Again, I think that there would have to be some other consideration for that.
What about the assumption of debt?
Sure. If there was, if under Judge Thuma's scenario, she got 30% of the property, he got 70% of the property, but he got 70% of the debt and she got none, and now that comes out to 50-50, or he got 100% and she got none, Yeah, absolutely. That
Well, I would
works.
assume that the debt is encompassed within, when you're saying 70/30, that means you factored in debt. But what if the parties just agree, we agree to a 70/30 split, and we both understand that wife is going to get more, or husband, whatever the case may be, but we agree with that. That's a net of any
Net of debt?
obligations. Can that be enforced?
I know it could be enforced, because if people submit that to the court signs off on it, and they never peep about it, it will be enforced, right? I mean, so yes, it could be enforced, but should it be enforced is the other question. And again, I think that's all based upon the circumstance, but to answer the question, yes, it could be enforced. Having said that, in this particular case, because wife wasn't represented at the time, because the postnuptial agreement wasn't even provided to the court in the decree entering stage, and because wife, it's clearly unfair, I just don't understand how that can be the basis for a court turning her head and saying, well, you signed it, therefore you're stuck with it. And that's pretty much what she said. I also want to remind the court that once the judge issued this order, we immediately filed a motion to alter amend, and it was 100% on legal issues. Okay, judge, you didn't look at 25-318, you didn't look at 25-319, you didn't look at Harbor Osmond, you didn't do the fairness analysis, and the court just summarily denied the motion to alter amend. So I don't think it's appropriate to say, oh, it's an inherent finding in there, because we pointed out the law to her, and she just summarily denied our motion. The other thing I want to remark on is the just again, the bridge that we talked about in spousal maintenance. There's no bridge in this case. She got nothing. So that's sort of a demonstration that this is unfair. Thank you.
Thank you. Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.
Thank you, Your Honors.